Okay. And maybe I'll just admit everyone, and then if you can keep an eye on it from there.
Will do.
Good evening, everyone. We will be beginning the online information session here in just a moment. I'm just waiting for everyone to indicate that they are just kind of connected here. We will be having microphones muted by default as we begin, just so that there isn't any inadvertent background noise along the course of the presentation. If you have any questions or any thoughts that you'd like to contribute along the way, we can either receive that at the end, or if you want to just message Jane or myself, Brad, in the chat, we'll be happy to either raise the question or give you the opportunity to unmute towards the end. With that, I am going to just note that this is being recorded for folks unable to attend. We will have a YouTube link that the Summer Village will be able to put onto their website. So I'll just give it a few seconds here and then we'll begin in earnest. Thank you, everyone, for the opportunity to present to the Summer Village of Half Moon Bay an update on the Summer Village's Land Use Bylaw Review and Modernization Project. My name is Brad McDonald. I'm with Municipal Planning Services, the Summer Village's planning consultants. And also with me tonight is Jane Doffney, also with Municipal Planning Services. There are members of council and administration in attendance just to keep apprised of this information session as it goes along. But we're going to be providing you with a bit of an overview of what is proposed to be changed, proposed to be kept, and proposed to be revised in the Summer Village of Half Moon Bay's land use bylaw. This is, as I mentioned, being recorded, and that YouTube link will be available in the day or so after this information session for anyone to view at their leisure. The purpose of the open house this evening is we would just like to give everyone a bit of an overview of what a land use bylaw is, some information about the Summer Village's current land use bylaw, what the overarching vision and guiding principles have been for this project, specifically as developed by council in their review of not only the current land use bylaw, but our work in helping them to prepare a draft land use bylaw. What some of the key steps were that we undertook with council and administration to get to where we are today. To, I think, probably why you're here, to go over what some of the proposed changes are in the current draft and give you an understanding of what is proposed to be changed and what is remaining similar to what it is today. And to give you an understanding of what some of the next steps are for council, for administration, and what future engagement and adoption processes may look like when we get to that point. So a land use bylaw is a mandatory bylaw that all municipalities are required to adopt. It is something that the city of Edmonton has. It is something that Red Deer County has. All summer villages on Sylvan Lake are required to adopt one, regardless of the size of your municipality, whether you have commercial and industrial developments, or if you are just a small municipality with a few people. All established municipalities in the province of Alberta are required to have a land use bylaw. It is the bylaw that establishes what the processes are for doing development and subdivision in your community. So if you are looking to apply for a development permit, apply for subdivision, receive notification of a development happening in your community, if enforcement is something that has to be undertaken, or if you're appealing a decision of the development authority, all of those processes are in the land use bylaw. It is a bylaw that establishes what the different regulations are for development of different specific and general types of development. It is the bylaw that you would go to find out how tall a home could be in your summer village, how tall a fence could be, what the side yard setbacks would be on your lot, if you could do commercial development, if you could have more than one home in a lot, things like that. If you want to know what that quantitative um, content of development could be in your community, that's where you would look to find it in your land use bylaw. It's a um, it also is required to include different districts, so land use zones, as it's sometimes called in different jurisdictions. And it identifies in each of those districts what different types of permitted and discretionary uses are allowed within each district. So a permitted use would be something that is allowed almost as of right if you complied with all other regulations in the land use bylaw. And a discretionary use would be something that the development authority could consider if it was deemed to be an appropriate use on that particular site. A land use bylaw is often the biggest, the longest, sometimes the most boring bylaw any municipality will adopt because it has to contemplate all different development scenarios within your municipality and provide guidance not only to prospective applicants but also um, to the summer village itself, to adjacent municipalities in terms of how development will occur and what application requirements are needed in order to um, entertain the idea of different development within your boundaries. The current bylaw for, sorry, it's current land use bylaw for the summer village of Half Moon Bay was originally written in 2013. So not a terribly long time ago, approximately 12, 13 years ago. We've seen many land use bylaws that go back into the 90s that are still on the books today. It's not terribly long by land use bylaw standards. It is approximately 50 pages long. Still a very long read, but it is not as long as some municipalities' land use bylaws. Given that it is 12, 13 years old at this point, it, the primary issue with it is that it is not consistent with many new and updated provincial acts, regulations, policies, department and agency names, and other um, important processes that are a land use bylaw is required to be consistent with on the province's end of land use and development. So by being inconsistent with those, it leads to a situation where the Summer Villages Development Authority, their subdivision authority, their appeal boards have to kind of flip back and forth between provincial legislation and regulations and the land use bylaw to figure out what they should be looking at in terms of required processes. This land use bylaw is not something that is written in stone necessarily. It's been amended 4 times over the last several years, going back to 2016 and as most recently, I believe, as 2022. So there is a process that enables council to consider amendments, changes to the land use bylaw, have a public hearing, and consider it for adoption. This land use bylaw was not updated when it was most recently updated to be consistent with requirements in the Summer Villages Intermunicipal Development Plan that has been adopted with other Sylvan Lake municipalities. And specifically in there are in that planning document that is almost an intermunicipal agreement. There are requirements that when a land use bylaw is updated or amended, that regulations with respect to development near major water features, water courses, and other environmental features in your community, that those be incorporated within. It's something that all Summer Village and counties around the lake have agreed to. So it's something that needs to be brought into this land use bylaw. Guiding this whole process, to council's credit, it's something that we've not seen in any of our work in doing land use bylaws, but council has prepared for themselves vision statements and guiding principles to kind of lead their review of the current land use bylaw and our work in making recommendations for what we feel should be included in your updated land use bylaw. So overarching all of this is a vision statement the council put together that I'll just read, not from the voice of council, but as something that they provided to us. So their vision for for a new land use bylaw for the Summer Village is to protect the community's historic charm while enabling redevelopment in a careful, practical way. Council believes that the land use bylaw should nurture the existing character of the Summer Village, reflect what residents value most, and safeguard the Sylvan Lake watershed and aquifer. Also, kind of spilling from that, council had guiding principles that they felt were important in their review of just about every regulation that they had an opportunity to kind of work together to review and consider whether it was in the best interest of the Summer Village. So these guiding principles include maintaining a country lane atmosphere, capturing the peace and charm of the rural life away from city bustle, to protect and manage community forests, vegetation, and green spaces to ensure long-term sustainability, to encourage outdoor activity to promote health and well-being, to manage the streetscape to foster community identity and vibrancy, and to ensure development is designed to maximize natural light and solar access and ventilation wherever possible. So these were very important things for council, both in our work in reviewing and preparing recommendations for the land use bylaw, and in their work in reviewing the um, drafts that we had provided council over the last little while. So this project has been going on for a little while. It began in 2023, and it kind of kicked off with a newsletter and survey to Summer Village residents in 2023, where we asked a series of questions about land use and development matters and priorities of the community to get a sense as to whether that work aligned with the guiding principles and vision statements that council had. In the response to the surveys, we prepared a report for council's consideration that summarized those responses. And from that, we were able to work with council to kind of identify what some priorities would be for the project. Since 2023, we've met a few times, council, our office, and Summer Village administration, just to discuss specific land use and development matters, to review proposed content in the land use bylaw, and just to discuss, ways to achieve those guiding principles in the land use bylaw. On the Summer Village's website, there's a copy of the draft land use bylaw, and there's also a supplemental information report that was shared out for Summer Village residents to have a look at, and I invite you to do so. The information report, supplemental information report, includes a little bit more of a deep dive into the rationale for different definition changes, proposed definition changes, proposed regulations, and why some things have changed and why some have not. So we're at the point here in the information session where I'm going to get a bit into the some of the proposed changes. And I just want to reiterate that if anyone has any questions along the way, I would invite you to just use the chat function in Zoom to direct questions to either Jane Daphne with MPS, my co-host for this evening, or myself. And we'll do our best to either answer them along the way or give you the opportunity to unmute as we go along and ask a question, or we can kind of save it up to the very end of the presentation. So the draft land use bylaw that's available on the Summer Village's website isn't a red line version of the current land use bylaw. And that's in part because as part of this project, working with Summer Village administration, we made the effort to do our best to align the structure of the document to be as consistent as possible with some of the other Summer Village land use bylaws around the lake, where you share development services. It sure makes it a lot easier for your development officer to kind of have an understanding as to where definitions are located in the land use bylaw, where information about appeals and enforcement, that if they're all in approximately the same location, that it makes their work a lot easier and there's less chance of confusion and delay. So part of what we've done is kind of restructure the entire document and kind of move things along so that they're uh, more aligned with what North Glenwold, Jervis Bay, Birch Cliff, Sunbreaker Cove have in theirs. So as a result, there isn't an easy way to show that without the entire document being kind of redlined out. But hopefully this summary gives you a better sense as to what some of these changes are. They're not all the changes that are in the land use bylaw. We're just hoping to kind of cover what some of the bigger ones would be. And we invite you to have a look at the draft land use bylaw. And if you have any further questions, we're happy to entertain them as we move through the weeks and months ahead. So on the side of summary of proposed changes, one of the things that we added to the land use bylaw, the draft land use bylaw, is a list of amendments. The Summer Village has done a great job of identifying the amendments on the cover of the land use bylaw as it's currently adopted. But we felt that it was important to identify what those amendments are. So we included a section in here that administration would be able to fill in to provide you with an understanding of not only when the land use bylaw was amended, what bylaw was used to amend it, but also what a summary of those proposed changes were, or sorry, what some of those approved changes were. So I provided a bit of an example of what that would look like. And in this case, it was a hypothetical amendment that would repeal and replace a definition in the land use bylaw. So by doing so, you'd be able to, as soon as you open up the document, be able to have an understanding of, how it was changed over the last little while. It's something that is not approved as part of the land use bylaw, and could be updated by administration as amendments come in. We also included a land use bylaw user guide as a bit of a preface to the document to help assist folks with reading and using the land use bylaw. As mentioned before, a land use bylaw is a very long document. It can be very difficult to read. We do our best to use as plain language as possible, but in some instances, it just has to include a lot of technical terms that can be a bit confusing or difficult to understand. So we provided a user guide to give you an understanding that individual regulations and individual statements in the land use bylaw can't necessarily just be read in isolation. That if you're going to try and find out information about developing a fence in the summer village, you can't just look at one regulation related to fences, that you would have to kind of get into a few different sections to have a better understanding of what you are required to provide and do as part of your proposed development. So hopefully that is something that assists folks in having a look at the land use bylaw. And as part of it, it invites development proponents to contact administration to better understand what application requirements and what they're allowed and not allowed to do within the summer village. The introduction section largely has been left alone. We have updated many of the definitions, which I'll get into on the next slide. We've updated the title of the document to reflect that there will be a new land use bylaw number. Rules of interpretation is a new section that was added to help better understand what will, may, should, must statements and things of that nature. Just to reiterate that how those statements are to be interpreted. We updated information about forms and fees associated with the land use bylaw, as well as severability. So if a particular regulation in the land use bylaw were to be deemed invalid, that the rest of the land use bylaw would continue. And same for repeal, that the current land use bylaw, once this one, or if this one is ever adopted, that the current land use bylaw would be repealed, that there wouldn't be two land use bylaws floating around for the summer village. The definition section, section 1.4, within the introductions section, is a bit of a lengthy section. It includes a lot of definitions for terms that are used in the land use bylaw, and some used in discussions with your development authority. So we wanted to update that as much as possible to include as many important terms that are used in the land use bylaw, and to ensure that they are consistent with legislation as best as possible. And where possible, we try to make them consistent with development terms used in some of the other summer villages, so that there isn't 5 or 6 different languages being used around the lake to refer to the same thing. So where possible, we've looked to um, consolidate and make consistent some of those terms, but also add a fair number of new ones that are terms that are used in the land use bylaw, and in some of the proposed new regulations. So some of these are technical terms, so things like semi-waterfront lot versus a back lot, what the legal bank is, what a development design plan is, landscaping, how landscaping is different than mowing your lawn, a real property report, non-permeable surfaces, and other terms that are used throughout the land use bylaw. We've also included some specific use terms for types of development that you may be either looking to do or that your neighbor might have, just so that it's defined and everyone is consistent in their interpretation of it. So within this section, the current land use bylaw has about 90 different definitions. And then to cover some of the terms that were not defined in the current land use bylaw, but also to cover the proposed new regulations, we have this up to about approximately 156 different definitions. And we aren't getting paid by the number of definitions that we provide in the land use bylaw. It's been our experience that the more terms that you have defined, there's less chance of confusion and misunderstanding of what these uses are, and what the regulations are that would be surrounding them. The section 3 includes information about amending the land use bylaw. As I had mentioned earlier, land use bylaws are not a static, written in stone type of document. They can be changed by council, involving a public engagement process that includes a public hearing. So if we were to adopt this land use bylaw today and then suddenly realize that a particular land use was not properly addressed within it, we could begin the process of having council consider an amendment to the land use bylaw. Um, in this section, it would identify who may apply for an amendment to the land use bylaw. And typically that can be any proponent within the community. Could be administration, or it could be council itself raising the matter. It identifies what the process would be for accepting, reviewing, and processing the land use bylaw amendment application, and what the process would be for hearing that process out. And that includes holding the public hearing, and that the notification of that public hearing, how it is held, and how it helps inform what an amendment to the land use bylaw would look like. Just needs to be consistent with the requirements in the Municipal Government Act. So there are some minor changes in this section from what is in the current land use bylaw, but we just wanted to ensure that that process is as spelled out as possible for anyone looking to understand what changing the land use bylaw would look like. Section 4 is the section that covers um, all things related to development permits, what the application processes are, what the review process is on the administration side, and how contraventions are handled by the summer village. So this this section has a number of subsections within it that we'll kind of cover one by one as we go along here. They're all very important to understand in terms of how we get from the process of understanding if a development permit is required for a particular type of development, and if it is, what the process is for the summer village and the applicant to get to a point where shovels can go into the ground. So section 4.1, control of development, updated slightly. It just lays out what the purpose of development permits are and what the core responsibilities of a development proponent would be. That anyone looking to do development within the summer village has to not only comply with the regulations in the land use bylaw, but any applicable provincial, federal regulations as well have to also be followed. And if there are any easements, other agreements associated with the land in question um, that simply seeking a development permit doesn't um, uh, cancel out any obligations within those agreements as well. One of the most important kind of subsections within the development permit section is 4.2, development not requiring a permit. Not all land use activities in a municipality are required to have a development permit to proceed. These are often a little bit more minor land use activities that you can do on your property that we don't want you to have to be going down to the Summer Village office to go through the process of applying for. Um, so inversely, we also like to indicate that anything not on this list, and the list in front of you right now is not the full list. Just wanted to highlight what some of the more key ones would be. But in the document, both the current and the proposed new, if something is not listed in that list, it would require a development permit to get authority to do that type of development. So it's an important list to identify what isn't requiring a permit, but also to think about it from the inverse, which is if it's not listed, then it would require a development permit to proceed. So some of the proposed additions and revisions to this list are that we've clarified in here that a maximum of 2 movable accessory buildings with a floor area of 11.1 meters square meters or less and a height of 3.7 meters or less does not require a development permit. In the current land use bylaw, this just indicates that a movable accessory building um, requires, a movable accessory building with a floor area less than and a height less than does not require a development permit. It doesn't indicate a maximum number that don't require a development permit. So by including a number on here, any additional small accessory buildings would require a development permit to proceed. And this is kept to this is proposed to be added just to ensure that the number of accessory buildings on a lot is not kind of getting out of hand in any situations. Uh, Inversely, if you are looking to do an accessory building larger than this or taller than this, it would require a development permit. And that's true as it is today. There's a provision added in here for a maximum 1 woodshed with a maximum floor area of 50 square feet. Again, having one does not require a development permit. Anything beyond that would require a development permit. Same for a gazebo, undertaking a minor home occupation. So working from your home, being on a Zoom meeting like I am right now, that doesn't require a development permit. That's just a clarification. Council had us add in the use and installation of tented structures um, from a certain period onward, uh, as long as they're consistent with all the setbacks of the summer village in that applicable land use district, that they don't require a development permit. Things like roof-mounted solar energy systems, and any landscaping that does not affect off-site surface drainage. So if it's not going to cause water runoff into the lake, onto adjacent properties, or onto the road. That type of landscaping doesn't require a development permit. Section 4.3, non-conforming buildings and uses, covers how developments that don't conform to the land use bylaw as it's approved today, how they will be addressed going forward. So there are likely some, you know, homes and other developments within the summer village that, due to the fact that they're older, or that they were approved under a previous land use bylaw, that they don't comply 100% with what, the land use bylaw as it's approved. And the Municipal Government Act provides for how those types of developments can continue to be used and developed and redeveloped going forward. So if you have an approved development permit, if you were legally conforming at the time that the development had happened, that can continue. We just treat it a little bit differently in this land use bylaw. 4.4 covers application requirements for development. This has been updated to reflect some modern application requirements and what information that most development proponents can provide as part of an application. Just reflecting that we're 13 years beyond what the current land use bylaw anticipates people being able to provide. So we've updated that to reflect modern requirements in terms of the site planning that can be provided, information from the applicant, things of that nature. We've included a requirement that development design plans, when development is proposed within 30 meters of the bank, high water mark of Sylvan Lake, that those need to be provided. There's a definition for them in the proposed land use bylaw, and that's something that the Summer Village had agreed to as part of the intermunicipal development plan with the other summer villages and the two counties on Sylvan Lake. That when the land use bylaw is updated and reviewed, that requirement would be put in there. The section also identifies what will and what may be required to be submitted in support of a development permit application. So we've updated this to reflect some additional may requirements that the development authority was generally asking for in the first place. But by identifying it, it helps to reduce any misunderstanding of what these application requirements are going to be ahead of time. So things like a geotechnical report, visual impact assessments, environmental reviews prepared by qualified professionals, identifying pre-construction lot elevations, construction management plan, existing and proposed elevations of all buildings. Things that your development authority was probably going to be asking for anyway. Now it's clearly spelled out in the land use bylaw. The processing of development permit applications by the Development Authority. We've updated this section just to reflect what the new Municipal Government Act requirements are for timelines for deeming an application complete or incomplete, and how that process plays out. The development agreement section that has been updated, it identifies what conditions may be applied to a development permit, and when different development agreements may be utilized for development. And identifies what types of development may require those agreements with the summer village. So if construction of the development requires road access to complete lock grading to provide for the control of offsite drainage, and to require the proponent to be responsible for the repair of any municipal lands or infrastructure. So if your proposed development would be potentially looking at causing impact on municipal infrastructure, that is something that a development agreement may be required for. As we kind of go through this here, sorry, I just do see a comment here from Bill. Sorry, Bill, I will get that in a second here. Under section 4.7, that deals with variances. And variances are provisions in a land use bylaw that allow the development authority to enable a type of development that due to either special circumstances or unique site considerations, that it won't 100% conform in every way to the land use bylaw. So the Development Authority is empowered in the Municipal Government Act to allow for different regulations to be varied uh, to to see that that development can occur. That is something that has to be applied for. Uh, um, through the Development Authority, and um, the land use bylaw here covers a little bit of information about um, uh, what that would entail. So, for a variance, the Development Authority would be your municipal planning commission, who would be the one considering a variance request. It identifies what the Development Authority must consider when requiring those, or sorry, when reviewing those variance requests. And it puts a limitation on the types of variances that can be considered along the lines of maximum site coverage and the height of a building. So for those two considerations, there will be no granting of variances in um, for maximum site coverage or the height of a building. And that's the way the current land use bylaw is written. So we're not proposing any changes on that. Just wanted to cover a bit of the information about what a variance is here. And there was a question about side yard setbacks. I do have a slide coming up in the next little bit here that will cover a bit of that. Just going back to Bill's question, looking for clarity in the definitions, the size of buildings that are how measurements are taken at the outside of the structures, not at the inside of the wall, not the foundation that might extend past the wall. Um, Bill, sorry, I just don't quite follow if you're looking for me just to identify that. Jane, can I ask you to just have kind of a look into that question? And just if you can, just kind of pull that information up. There is in the land use bylaw different methods that are available to the Development Authority to identify, um, how to measure grade on a lot uh, for the purposes of identifying the height of a building, and recognizing that not all lots are, created equal and are identical. So maybe we can just provide a bit more information about that here in shortly. Oh, sorry, I think I went too far. Notice of decision, information about uh, how the issuing of a notice of a decision of the Development Authority is given. Those have had changes in the Municipal Government Act, which governs how a land use bylaw has to give the issue of a notice of decision. So we made that consistent with what's in the Municipal Government Act. Um, no changes under the section that deals with the cancellation of the development permit. And again, it just identifies that a development permit may be canceled and for what reasons that the Development Authority would, cancel a development permit. Compliance with other legislations. So I covered this a little bit before, but it is in this section that we just provided reaffirming that having a development permit doesn't excuse you from provincial or federal laws and regulations, any other municipal policies, or complying with easements, agreements, etc. Jane just provided me with some information from the draft land use bylaw. She just wanted to provide a follow-up to that question, that setbacks are measured from the outside of the building and floor areas from the inside of the wall. So hopefully that helps there. We do have a new section in the land use bylaw dealing with subdivision applications. Um, the Summer Village likely is probably not going to get a lot of subdivision activity, given your size and your built-out nature. But all land use bylaws are required to include information about how notice of a decision of subdivision authority is to be given. And as a result, we included a very brief, basic framework for how subdivision applications are to be provided, how they're to be reviewed, and how decisions are made. Um, this summer village could have lot consolidations as well, which are a type of subdivision. Um, and we just wanted to provide some sunlight on this topic in the land use bylaw. Um, Section 6 deals with appeals. So an appeal is launched on a development or subdivision appeal, this section covers how that appeal may be made, by who, and to what body now. The current land use bylaw deals a little bit with appeals, mainly to the local subdivision and development appeal board. But the province has changed a few things with respect to appeals, and now many appeals, particularly for summer villages and other municipalities adjacent to lakes and other important water features, sometimes those go to the Land and Property Rights Tribunal, which is a quasi-judicial arm of the province for appeal. So we had to update that it could go to the local STAB or the Land and Property Rights Tribunal. And we separated out what the processes are for development appeals and for subdivision appeals as well. They're very similar, but there are a few minor differences that kind of require them to be in their own unique sections. Section 7 deals with enforcement. So if this section would cover in situations where development is occurring that is inconsistent with the land use bylaw or is inconsistent with the conditions of a development permit. And as best as possible, we try to kind of spell out what the incremental process is for enforcement in the summer village. Um, there's a little in the current land use bylaw that covers on this topic, so we wanted to kind of spell out in a little bit more detail what that looks like. All of this information is enabled for and provided in the Municipal Government Act, um, but not a lot of people reflect back to the provincial legislation to figure out how enforcement is to be undertaken in a municipality. So having it in the land use bylaw just puts it in a location where both administration, council, and community members can have a better understanding of how enforcement is to be done. It outlines, that no person shall contravene the land use bylaw or a condition of development permit or a subdivision approval. It provides for, as indicated in the Municipal Government Act, the ability of your development authority, peace officer to um, uh, uh, assess on site if a contravention is ongoing, or if there's a health or safety concern with respect to development that is inconsistent with the land use bylaw or conditions of a development permit approval. So that right of entry provision is spelled out in the land use bylaw. It provides information about how warnings and final warning notices are to be given. Um, it identifies that anything with respect to offenses and fines, you'll find them in the Summer Villages fees and charges bylaw rather than the land use bylaw, just because the province has requested that all of that information be in a municipality's fee and charges bylaw. And there's also information too about how and when the Summer Village may issue a stop order, and what the appeal rights are for the development proponent if a stop order is issued on their development. And there's also some information too about violation tags and tickets and when they may be issued and how they are to be treated um, by individuals if they receive them. Section 8 covers general development regulations. And so these are regulations that largely cover all different types of development within the summer village. They are very well by the name of the section, they are general. They are things that would apply to all lots, all residential lots within the summer village. And they're things that are largely put in here to ensure that the size, scale, and um, uh, nature of the summer village is kept the way in which um, you would kind of want it to be laid out to be. This current section in the land use bylaw, as it exists today, has about 11 different subsections within it. In talking with council on different topics, we've increased this to 21 different sections. The proposed new ones are shown in red. And in some ways, they cover content that is currently in the land use bylaw. And we've move this to be in such a way that that they have their own subsections within. Um, but in some instances, they are entirely new as well. So things like lighting and surveillance equipment is new. Information about development on corner and double fronting lots, that sort of thing, and tree removal as well. Um, there is also a section that we'll get into in just a minute here, section 9, specific or special development regulations. They cover regulations that deal with individual specific types of use. So accessory buildings, driveways, fences, things that are very, very specific. So I do have a little bit of information about tree removal that just to cover tonight, but I certainly invite and encourage everyone to have a look at these sections in Section 8 General Development Regulations, uh, just to have a sense as to um, how the land use bylaw is proposed to cover these topics. Section 8 tree 820 tree removal. There are tree removal provisions in the current land use bylaw today, even though there isn't its own section. The current land use bylaw identifies that any development permit application um, must identify if trees or shrubs to be removed as part of the intended development. And there is another statement further on in the land use bylaw that states that the conservation of existing trees to the maximum extent possible is a standard of landscaping for residential lots. So the current land use bylaw hopes to avoid the removal of trees unnecessarily. Um, and if they are to be removed as part of a new development or a redevelopment, that they be identified on the development permit application. Council, in meeting with us several times, certainly wanted to promote the idea of maintaining to the maximum extent possible the tree canopy within the summer village. And we explored options to have the removal of non-hazardous mature trees requiring a development permit. So if it's part of a development permit application anyway, that's fine. But if you are just looking to remove non-hazardous mature trees from a lot, that go through a development permit process. And so that the summer village can help identify how new trees are to be planted to replace any trees lost, and that the application requirement, the application identify things like the reason why the trees are to be removed, a description of what is to be removed, site plan showing what some of the natural features are on the site, information about how and when the debris is to be removed, and if required, arborist reports and landscaping plans to supplement the application. Section 9, the specific development regulations. Um, sorry, I have the wrong numbers up in the content and proposed changes cell there. The proposed new uh, there's not a lot proposed to be new in this section. I think recreational vehicles is the only topic to be covered here as something that is in its own new section. A lot of this content, accessory buildings, driveways and parking, guest house suites, tourist homes, that's content that's in your current land use bylaw today. And largely a lot of those sections have been either left alone or have had minor tweaks to reflect council's thoughts on the topic or administration's experience with dealing with development on those topics. We added a section about recreational vehicles. Recreational vehicles are addressed in your current land use bylaw, but not in their own section. They're covered under uh, objects uh, objects that may be kept on a lot. So we wanted to pull that out just to be in its own section. Uh, Covering a few of these topics for you. Again, we implore you to have a look at the current draft and have a look at everything in there. But just wanted to bring some of these topics to your attention that I know were either big discussions with council or just from our own experience are topics that are um, something that folks might want to have a closer look at. The current land use bylaw indicates that any accessory building with a floor area of less than 11.1 square meters and a height less than 3.7 meters can be developed without a development permit. And we covered this before in section 4.2, but just wanted to reiterate that that it states that in the draft land use bylaw, we put a qualifier on there to say that you can have one with a floor area of less than 11.1 square meters and a height less than 3.7 meters without a development permit. So any additional beyond that just would require a development permit application. And that's largely just to ensure that the maximum site coverage of the lot, which is something that again is consistent between the current land use bylaw and the draft land use bylaw, that's not being exceeded without consideration of what's on the ground today. The current land use bylaw provides a maximum of two accessory buildings on a lot, and that's in the number of buildings on a lot section. We kept that the same in the draft land use bylaw. Same for maximum height. Any accessory building without a garage suite can only be 5 meters tall. Oh, sorry, I have sorry, I had this just slightly wrong here on the conversions to feet. My apologies. Without a garage suite, both in the current and in the draft, can be a maximum of 5 meters tall. If you are developed as a garage suite, um, you can be a maximum of 7.6 meters tall. And that's in the current draft land use bylaw as well. And that's generally just to provide a bit more headroom clearance, noting that a garage suite typically has the living space above the garage itself, and to be able to provide the headroom necessary to have that space for a suite. And in both cases, an accessory building can't be used as a principal dwelling. So you can't have a shed on an undeveloped lot and live in it. Under driveways and parking, just some minor tweaks in this section as well. In the current land use bylaw, it states that a lot can have a maximum of one driveway if the lot has a width less than 40 meters. And if you were larger, or I guess wider than 40 meters, you can have a maximum of two driveways. In the draft land use bylaw, we made some adjustments to just indicate that a maximum of one driveway on a lot. And that is to just reduce the amount of coverage over the drainage corridor along the side of the road. Maximum width in both instances is 10 meters wide. And there are provisions in the current land use bylaw that indicate that a driveway shall not interfere with the natural flow or absorption of water, and that it must contain culverts and is graded to the satisfaction of the summer village. So we did include some very similar language to that it shall not interfere with the natural flow or absorption of water, that driveway construction shall not disturb or disrupt municipal stormwater management infrastructure, and where the road, storm, drain flow um, would be impacted by the construction of a driveway, that then you must have culverts that are designed and installed to Summer Village standards. There is a provision in the draft land use bylaw that's a little bit different that enables a driveway covered with non-permeable surface. Um, so if you currently have a driveway that is non-permeable, sorry, if it is permeable, and you're changing it to a non-permeable surface, that requires a development permit. Section 9.3 fencing, just some minor tweaks in the section as well. Um, so on a semi-waterfront lot, and that would be a lot that would be adjacent to the lake were it not for uh, lands within the EOS district or municipal reserve, environmental reserve. That if it were not for that, it would be adjacent to the water. The rear side yard setbacks is 2 meters. The front yard setback is 1 meter, and the flankage yard setback is 1 meter. In the draft land use bylaw, it's similar, except the front and rear and required setbacks are 1 meter. So that prevents situations where the rear yard fence, as it extends along the edge of the lot closer to the lake, that have a bit of a shorter fence to enable better views of the lake and vegetation adjacent to the lake. For back lots, non-semi waterfront lots, the regulations for fencing are the same. And these are the maximum height requirements in the land use bylaw, both in the current and the proposed draft land use bylaw. Um, Proposing to build a fence at this height or less does not require a development permit. So it would only be in situations where you are seeking a variance taller than this that you would require a permit for your fence. Under recreational vehicles, the current land use bylaw in that objects uh, being kept on a lot section, it states that on a lot with an existing dwelling, an RV, so a recreational vehicle, may only be used by bona fide tourists for a maximum of 30 days a year, or by the registered owner of the lot for 60 consecutive days following the issuance of a development permit for a temporary accommodation. Um, the bona fide tourist and the registered owners of the lot, it's something that is pretty hard for administration to be able to identify who's a bona fide tourist, who's a registered owner, how many exact days a recreational vehicle has been on the lot, how long it's been accommodated, or sorry, how long it's been used as an accommodation. Very confusing. The language is a bit confusing. Similarly, on a vacant lot, it indicates that only the registered owner can use it for a maximum of 60 consecutive days when a development permit has been issued for a new dwelling on the lot. Um, we made some tweaks with council to um, write this in such a way that it enables folks to have a recreational vehicle on their lot, that through a development permit process, it would just indicate where on a lot an RV would be placed, how water, wastewater, and other utilities would be provided to it, where on-site parking would be provided. And so that's on lots with an existing developed dwelling on the site. If you have an undeveloped lot, again, it would only be used only be enabled to be on a lot with a development permit when the construction of a dwelling that has been approved by the Summer Village is underway. So a very limited temporary time frame for that. The placement of recreational vehicle on a lot would be included as part of the lot site coverage. So if you are already kind of built out in terms of non-permeable surfacing on your lot, having a recreational vehicle would put you over that limit. So that's part of the reason why identifying where an RV would be placed on a lot and where on-site parking is provided. All of that information helps us to determine how much site coverage is being used up on a lot. And similarly, recreational vehicles shall not be placed in the rear yard of a semi-waterfront lot. So that's the yard that is adjacent to or more closely situated towards the lake. And that's so that folks looking out of their homes towards the lake are not looking at recreational vehicles rather than um, natural vegetation in the lake itself. Tourist homes, it's something that is currently addressed in your land use bylaw. Um, we're not proposing any changes to this. A development permit is required as part of a tourist home to operate within the summer village, and they are can only be issued for up to 12 months. We're not proposing any changes to this. And in fact, for many summer villages that we've helped prepare land use bylaws for, this was in many ways a bit of a guiding document for what proposed regulations could look like. Sections 10 through 14 cover the land use districts for the summer village and the land use district map. Um, the summer village of Half Moon Bay is quite small. It's probably one of the smaller summer villages that we worked with. And as a result, there are really two land use districts on the books today and being proposed in the proposed land use bylaw. And these are the R residential land use district. So all residential lots within the summer village would be within this land use district, and the EOS environmental open space district. And that is lands that are municipal reserve, other types of reserve, and generally are the natural areas of the summer village that are owned by the municipality. For each of those districts, we made some minor edits throughout to improve clarity, consistency, and readability. We made sure that the permitted and discretionary uses within each district were updated to be consistent with the definitions that are in the draft land use bylaw, so that we're not referring to one thing in those districts and something else in the land use, or sorry, in the definition section. And it just provides a bit more clarity about how the district boundaries are to be determined. So I'll just skip ahead here to the land use district maps. They are quite similar. The one on the left is your current land use district map. It identifies where the R district, the residential lots, are located, and the EOS, environmental open space district as well. The one on the right is the draft land use bylaw map. They're very similar. There is some additional lands identified as EOS in the draft land use bylaw, and those are very narrow, skinny pathways and buffer areas adjacent to the road that are also reserves that, for whatever reason, many years ago were just not included in the EOS district. But because they are uh, kind of important natural features within the summer village that are owned by the municipality, we've just included them within the EOS district as well. One of the more significant adjustments within the residential district that council kind of worked through was adjusting the side yard setbacks. In the current land use bylaw, it indicates minimum side yard requirements for residential development in the residential district. And this includes any side yard that abuts a reserve parcel, so the EOS district or a road, that side yard setback would be 3 meters. On specific lots, the side yard requirement would be 3 meters. Um, on if your lot has an attached garage, your side yard setback could be a little bit less, 1.5 meters. But if you're on a lot without an attached garage, that would be 3 meters. So there are very specific minimum side yard requirements. In reviewing this land use bylaw, council had very lengthy and fascinating discussions about how to best kind of manage open space and create a regulatory environment that would continue the country organic kind of feel to development within the summer village. Um, and in doing so, council kind of looked at having situations where Sorry, I just skipped ahead here by mistake. Not wanting development to just kind of take up the entire frontage of a lot, and go from one minimum side yard setback to the other minimum side yard setback and create a wall of building. That council wanted some variation, some unique um, variation in how homes were situated on lots, whether they were slightly to the left on one lot or slightly to the right on another, and hopefully creating visual corridors that would provide for greater natural areas and views of the lake from the street level. So in doing that, council proposed some minimum side yard requirements that require a little bit of um, kind of junior high math, but at the end of the day, I think can be interpreted by anyone that um, as they read through the district here. So what these minimum side yard requirements are in the draft land use bylaw is that each lot that the side yard setback shall equal 25% of the lot width. So if you are a 40-foot, sorry, yeah, a 40-foot lot or a 40-meter lot, um, that 25% of that must be your side yard setbacks. And one side yard must be a minimum of 1.5 meters. So if you are 1.5 meters on one side, the remaining portion of that 25% must be on the other side. So the other side would then be the remaining portion of the setback. Additionally, the width of the side yard um, shall be consistent from the front lot line to the rear lot line. So creating those kind of visual corridors along along the frontage of the street in the summer village. There was a question kind of going back to the recreational vehicle section. Um, I will preface again that some of the information that we had up on the slides aren't all of the regulations within there. One of the questions was, can we have additional recreational vehicles on a lot for the purposes of family visiting and that sort of thing? There are provisions the in that section in the land use bylaw, in the draft land use bylaw, that enable the development authority to allow additional recreational vehicles on a lot when that information is provided. So I'll just invite you to have a look at that section, and if that doesn't align with how you would or how you would like it to be, let us know. There'll be some contact information on that next slide. So generally speaking, the regulations contemplate having one recreational vehicle on the lot for a while. But if there are others potentially visiting for a weekend or whatever, there are provisions in the draft to accommodate that. So a lot of that is, sorry, that is a lot of information. Going through a land use bylaw is never easy. We could be here for another 4 or 5 hours and still only cover a portion of it. I hope that in me talking for a while here, we were able to cover what some of the major changes are, what some of the key sections that we invite you to have a look at are. And hopefully for anyone that hasn't had a chance to open up the land use bylaw, um, that this gives you a bit of an overview of how to read it and what to look for. After we kind of conclude this evening, and I invite people to ask us questions either in the chat or we can unmute if you need. Um, we will finish the recording of this and we'll post it on the Summer Villages website for anyone that was unable to attend tonight for whatever reason, or if you had to drop out or if you arrived late. We ask folks to kind of provide your feedback over the next couple of weeks here, going into April. I think this is about a month of kind of a soft requested deadline, so that we can get information collected, have a look at it, and compile it into a report for council's consideration with some recommendations on our end if there's questions being asked or proposed solutions to issues in the land use bylaw. We'll prepare that report for council's consideration, and we'll review it with them and discuss with council what changes might be needed to the draft land use bylaw. I have some dots here that just indicate that depending on what feedback we get, how much feedback we get, and how what the type of feedback is that we get from folks, it'll be up to council to determine if some additional meetings on our end are needed, or if significant changes are needed to the draft. So we'll leave that kind of open on council and administration's end to figure out what further changes are needed to the draft land use bylaw. But when we do finally get to a spot where council's comfortable with considering it for potential adoption, there is some additional engagement with the community that will happen. So after council gives consideration of the draft land use bylaw for first reading, we'll go through a notification period where the draft will be posted for community members and agencies to have a look at. We'll have a public hearing, which includes an online option similar to this as required in the Municipal Government Act. All public hearings dealing with planning matters like this have to have an online option. And depending on what we hear at the public hearing, we can prepare additional reports and amending motions for council's consideration. And as we get through all of that, if we were so lucky, council could consider the land use bylaw for second and third reading. So as we sit here today, our next steps are hopefully to get feedback from community members on what's in the draft land use bylaw, and then work with council and administration to incorporate that where possible, just to improve the document as best as possible. So with that, I'm just going to take a break here. I've been talking, I think, longer than anyone might necessarily want to be hearing from me. But if there are questions, I invite you to pose them to Jane Dockney in the chat or myself. And if you would like to speak, just maybe use the raise hand function or indicate in the chat, and we can selectively unmute people so that not everyone's chatting at the same time. Jane, have you received any additional questions?
I have. I'm just working through answering some of them. The one that I'm looking at right now was a question about whether or not the side yard requirement includes decks attached to the side of a building. If it's a deck attached to the side of the building, it's generally considered part of the main building, and then the side yard setback would apply. There are some exceptions depending on whether or not it meets the definition of deck or is considered part of the main building itself. And then there's some things that are allowed to encroach into the side yard. So, Brad, if you have any additional comments to add to that, I'll just find the section of the land use bylaw so we can reference that as well.
Yeah, and I think Jane, you kind of covered one of the things that we were talking about in terms of the definitions in the land use bylaw too. So to clarify what is a deck versus what is a patio, um, two people might call the same thing two different things, and having regulations respecting a deck versus a patio are important when we consider the height of a deck or the height of a patio.
So section 816 is projections into yards, and that section provides more information, more detailed information into the types of structures or developments that are allowed to encroach into those side yards. So, Bill, I'd ask you to have a look at that section, and then if you have any additional questions about that, just reach out to us.
I think generally speaking, those encroachments are things like eaves, uh, cantilevered windows, a few other kind of features of a home that might protrude a little bit further than the main walls would.
Yes, it doesn't include decks.
Okay. But that I will write that down too, just to clear, just so we have information about whether patios, so basically structures that are below 2 feet in height, could be extended into side yard setbacks. Anything further on your end, Jane?
It also just clarified too that the information I gave you regarding how we determine floor area was incorrect originally. The definition of floor area that's in the draft land use bylaw indicates that the floor area is to be measured from the exterior of the foundation, so from the outside. And one of the comments we received just as we were reviewing that information was, well, what if it's an accessory building that doesn't have a foundation? Then where do you take the measurement from? And I think that's a really good point that we should flag for council, is that that definition might need to be reworked a little bit so that it is appropriate for buildings with foundations and buildings without. And then there was one more question comment about how you determine essentially the high water mark or the legal bank and whether or not that's something that the Summer Village would do. And the information we provided in response to that was that unfortunately, the legal bank or the high water mark is a fluctuating line in many situations and on different lots. So it can be a line that's defined on a plan or plans, depending when the plans were registered, or it can change. It can move if there's been accretion, or it can sort of move into the lot if the water level of the lake rises. So it's something that would have to be delineated and in some instances negotiated on a site plan when a development is being proposed.
We did get a comment here about the land use bylaw update process itself. Just seeking some information about the survey from 2023. That was sent out to all Summer Village residents. And I know that that survey was sent out multiple times, I believe in the spring of 2023. The first time around, it had a very low response rate. So the Summer Village asked for it to be sent out again. We did get some additional comments back, and the response rate was about 20%, which is not a lot of people considering how small the Summer Village is. But in our experience, a lot of these type of surveys don't get, a lot of responses in the first place. As much as we would love to get everyone's opinion on different topics and such, we just can't, um, you know, force them to provide responses and answers to it. Um, so that's how that process went along. In terms of additional consultation on this, we would have to defer to council about whether additional surveys or engagement opportunities would be warranted or needed. At the end of the day, the adoption of the land use bylaw or amendments to a land use bylaw is a decision of council. It does require there to be a public hearing and engagement of the community. But at the end of the day, whether changes to a land use bylaw are approved is a decision of council. So we'll chat with council more about whether additional engagement is needed or warranted on their end. Um, but we did our best to reflect what those comments were from the survey and using council to kind of guide us through those comments and what they wanted to see in the land use bylaw. Uh, Part of the comment too was that the current land use bylaw kind of works today, that it kind of strikes a good balance um, uh, of what works in the community today, and that any further restrictions may affect property values and residents' ability to design and build homes. Um, we did I think in reviewing this land use bylaw, we did keep a lot of the current content in there. As a land use bylaw that's not terribly old, it works quite well in some respects. So a lot of the sections, if you look at the current versus the proposed new, there's not a lot of changes in there. There's some changes that we had to make to reflect the provincial requirements and to reflect uh, the other planning documents in the Summer Village. But as guided by council and administration, we also did some additional changes that hopefully reflect community priorities, but again, let us know as you further review the documents if we're out to lunch on any of this. Jane, do you have anything further? I'm not getting any additional comments on my end.
Oh, just
Oh,
working.
sorry. We do have a, sorry, Jane, did you? And then I can,
Just a question regarding whether or not a covered porch attached to a dwelling can encroach into the yard setbacks. So, covered porch attached to a dwelling would be considered part of the dwelling itself. So, it itself can't encroach, but the eaves off of it are enabled to encroach a certain amount into the required yard setbacks. I hope that clarifies it a little bit. If not, just send us a follow-up email and we can sort of talk about the specific situation on the lot, and I can provide clearer information in relation to the specific question.
awesome. I had Rob asked if he could just make a comment, so I just unmuted Rob.
Hey, thanks, Brad. Can you hear me okay?
I can, Rob, thank you.
All right. Well, thanks for putting all this together. I did want to make a comment that, I got the letter in the mail here, and it was really the first I had heard of any of this. I'm one resident out of many, but let me be the first to say, yeah, no, I'm not in favor of really anything I saw today. And that sounds maybe a bit surprising to hear, but I don't really see any improvement. Um, and I don't know where we're at in the process, but it seems to me like, okay, we're trying to protect the charm of the neighborhood, but all the rules and permits and things required are going to affect that. That's bugging me to hear the first of this. I had plans to build personally a home on my lot, and these new setbacks are drastically affecting what I'm able to do. I have already built a garage that cost me $70,000. That was part of that future plan. And yeah, no, I'm not. I'll be the first to sort of say, yeah, no, I'm not in favor of any of this as one resident. I would ask that council put out a vote of some kind or maybe be a little bit louder. I do not remember receiving a survey. I apologize. I do not. If I did and I knew it was this drastic of a change, I would have replied in the least. So yeah, I'm just going to put that out there. I know the members of council are on here. Please take my comments into consideration. I appreciate the work you guys do. I know it's not, I know it's a thankless job, and we've done lots of great things in the community, but I'm concerned about pretty much everything I saw tonight. And I'm not trying to be an alarmist, but I think you get the sense where I'm coming from. I'll leave it at that. Brad, thank you so much. I appreciate you giving me the time to put in a comment.
Yeah, thanks, Rob. I'll let I've taken it all down and your longer comments that you put in the chat here to me as well. I would invite you. Maybe we can have a conversation in the coming days here if you kind of want to
Sure.
speak a little bit more specific about your development plans and how the current land use bylaw reflects it and how the draft one might be changing things and then we can help formulate some recommendations for council's consideration on it.
Right. And I mean, just as an example, if I've got two people visiting me for a long weekend and they've each got a trailer and I've got to apply for a permit, I mean, what are we doing here, guys? Thank you very much, Brad. I would really appreciate somebody reach out to me and
Yeah.
maybe help me understand this better, because yeah, I'm concerned for sure.
Okay. Yeah, if you reach out to the Summer Village or just send me an email as on the screen there.
Send an
We'll
email directly to you.
yeah, if you email directly to me, I can give you a phone call or we can have an email chat or something.
All righty. And can you just help me understand where we are in the process? It looks like we're at the public hearing part of the process. Is that correct?
Um, no, like this is this is the opportunity for community members to kind of have a review and understanding of what's in the draft land use bylaw for the first time. From the feedback that we get today and in the coming weeks, we will be proposing some changes to the land use bylaw on some of these topics that you raised with respect to recreational vehicle and what Jane was talking about with respect to
Tree
side yard
removal,
setbacks.
tree removal. Like, do I need to list them all here, or like, let's have a conversation because I've got many concerns. I know others, my neighbors feel the same way. Some of them, please reach out to me. I'll send you an email.
Yeah, any emails that we get, we'll include it in our report to council, and as summary to what we hear tonight. We don't expect everyone to have even looked at the draft land use bylaw. But we wanted to give an overview of what's in it and how to have a look at it and how to reach out to us if you have further questions. But whether it's comments here tonight or emails, phone calls in the coming days, all of that we're going to collect for council's consideration.
Okay. Thanks for the time, Brad. I appreciate it.
Yeah, and look forward to connecting in the future here.
Thank
Thanks.
you, sir.
Jane, do you have anything further?
No, just another person indicated that they agreed with Rob, so I've recorded that as well.
Okay, thank you. Good. Well, I'll give folks another minute here. Just if you have comments, you can throw them in the chat or just ask to speak. But again, just reiterating that um, comments tonight or in the coming days, we just kind of ask that you send them by April 8th. Anything that comes after that, we'll do our best to. They'll definitely be sent along to council as well, but we hope to have a summary of feedback to council later this spring so that they can kind of have a look at all the feedback that was provided and make decisions about how to go forward from there. All right, so I'm not receiving anything further. Jane, I'll give you kind of one last check on your end.
Nothing further.
Okay. Well, with that, I will we'll just say our good nights here. Again, if anyone has any questions, feel free to reach out to me. The information you can reach out to the Summer Village; they'll provide it. How to reach us, or you can contact myself, Brad McDonald, at the email listed above. There's contact information for Kara, the development officer for the Summer Village, up here as well. So. I want to say thank you to everyone for giving us your time on this evening. I know there's no good time to kind of give our time for things like this. Everyone's got busy lives, and I want to thank you for attending tonight and all the feedback that we received so far, and um, all the feedback that we're going to get in the next little while. So thank you very much. I will stop the recording. And say goodnight to everybody. Thank you.